All right, welcome back. All right, please sign in for the attendance. There are a lot of people not here right now, which is not going to be good. Let me talk for a minute about attendance and why am I so tough on this. You are entering a profession where timeliness is very important. I read a story recently where a lawyer was in court waiting for the judge to call a case for trial. The lawyer went to the bathroom for a few minutes. The case was called for trial while the judge was in the bathroom. The case was dismissed. This isn't a joke. This isn't me being unreasonable. A minute late means you blew the statute of limitations. You can't get up in the middle of the trial to go to the bathroom. That's not a thing, right? You can't get to court late because then you lose your case. The case is dismissed. To the extent I can, I make law school as a way to get you ready for what comes next. And far too many students take attendance cavalierly. We all have issues at home. Things come up. You have a job to be here on time. You're given 5 absences, which in my mind is too many. I think I missed maybe 3 classes in all of law school, and those are for interviews. Unless there's a health condition, you should be here every day, on time, ready to go. In my property class, I had to do a makeup because of the storm. We had canceled the class, Imelda. And I gave people the option of watching the video as a makeup. 50% of the class didn't even watch the video. It's an absence. I don't get it. I really don't. You're here. You're spending a lot of money. You're spending a lot of time. Make every minute count. Anyway, so now someone's going to walk in right now, and I'm going to have to yell at them. But there's a reason why I do this. I guess it's not working because people aren't getting the message. But that's why I have to keep harping on it. All right, makes sense? And there are now, by my count, at least 15 people absent. Okay. Hopefully everyone had a good Rosh Hashanah if you were celebrating. If not, hope you had a nice day off. I had a good holiday. Any questions on material from last week? Last week we covered the executive power with cases like Korematsu and Hirabayashi and Endo and Dames and Morvey Regan. Any questions from class from last week? Oh, no, you're not raising your hand. You're raising your charger.
Yeah, I'm sorry.
That's OK. It looks okay you're raising your hand. Any questions from last week? OK, let's move on. I mentioned last week that there are very few cases involving the executive power. There are just not many of them. And the reason why is that generally the courts don't get involved when the executive is trying to exercise his authority. That's generally a matter for the political branches to work out. Same for our topic today, which is called the separation of powers. There are very few Supreme Court decisions involving the separation of powers. Why? Generally, it's because the political branches manage to work it out themselves. You know, today we think that every single dispute goes to court. That's kind of novel. That wasn't the way things used to be. The 2 cases for today, first one is Morrison against Olson. The second one is Noel Canning, are instances where the separation of powers cases spilled into the courts. And in both cases, the government more or less prevailed. Noel Canning's a little bit trickier, but they won in the big picture. And generally, the courts are deferential when the branches try to do something, and they don't try to come into it. OK? So let me ask a question. Anyone remember where I was last time? OK, Brandon, let me ask you a question to start off. I'll do the poll question a little bit later. Brent, let me ask you this question to start off. Why do you think it is that most cases, most conflicts between the two branches don't wind up in the courts? I mean, I gave you the reason because generally the branches work it out, but what's the actual legal reasons why these issues generally don't come to court when Congress and the president disagree?
Maybe the court doesn't have the power.
Oh, that's a good point. Generally, when is the court able to intervene? Like, what's to happen for the court to be able to step in?
It has to be a legal issue.
Yeah, right? There has to be some sort of legal dispute, right? You can't just go to court and say, you know, I'm the president, I don't like what Congress is doing, right? Or the Congress can't go to court and say, you know what, I don't like what the president's doing. There has to be someone who's actually injured. And the cases we've studied so far illustrate that. Think of Korematsu, right? You had a guy who was excluded from his home, right? Dames and Moore. You had a company who had some money owed to it by the Iranian government. That money was wiped out. What about our cases today? You have a guy named Ted Olson, who was a government official, who was being investigated. That's an injury. And the second case, Noel Canning, you had a company that was being disciplined by this federal agency, right? That's an injury. So these are the rare cases where you actually have a live controversy that makes it to the courts. Okay. Now, Sergio, let's do a little bit of recapping. We did a case, I think last week, called Youngstown, right? The steel seizure case. And this was an important case because it had many opinions. And the different opinions had different approaches to resolving these sorts of separation of powers disputes. If you want to check your notes, that's fine. But I want to start off by remembering Justice Black's opinion. How did Justice Black, Hugo Black, go about interpreting the separation of powers? How do we describe his approach?
Yeah, give me 1 second. Let me pull it up.
That's okay. That's all right. And Rich, you're next. You want to pull up your notes also? Again, yeah, Matt, you're probably in deck also, so just get it ready.
Okay, so Justice Black wrote that any exercise of power for the president must come from either the Constitution or Congress.
Yeah, based on the text of the Constitution, right? How do we describe, Sergio, Justice Black's approach to the Constitution? What sort of label do we give it, if you recall? Like, how would we describe that?
Is it textual?
Textual, it's good. What's a word I'm thinking of? Anyone know the word I'm thinking of?
Originalist?
No, originalist is good. Now I'm thinking of, but that's good. Begins with an F.
Formalistic?
Formalistic, right? Ethan, what does formalistic mean?
That they strictly stick to the text of the Constitution?
Yeah, formalistic is very like rigid, right? You're sticking to the text, you're sticking to the structure, right? And the Black opinion is very like, look, does the Constitution say the president can seize property? No, it doesn't. Therefore, the president loses. Now, Richie, what's one of the downsides of this sort of formalistic approach? Why might this be subject to some criticism?
Because, I mean, there's the prior opinions on how the Constitution, I guess, should be interpreted. And I guess one of the downsides would be when you're interpreting the Constitution, it's not, you're not taking it how it's written, I guess, and your interpretation would be different from somebody else's interpretation.
Well, in this case, does the Constitution really speak to the question of whether the president has the power to seize property? This one's maybe an easy case, right?
You're talking about
In Youngstown, does the Constitution say the president can seize property? Is there any provision that says the president can take property? No, so I think that's more of an easy case, right? But think of the case for today, right, Matt, with Morrison against Olson. Does the Constitution say anything about whether the president can fire people?
I mean, I think they felt like it was implied in the take care clause.
Okay, good answer. Implied. Okay, what does implied mean as a general matter?
Well, he's to appoint ministers, and so
No, but the word implied, what does that word mean
Oh,
as a general matter?
Something that can be inferred from the.
Right.
I don't want to. I think you have that.
You remember very good. Right. So I think Matt raises, and I think Richie also raises a fair point. The formalistic approach, not formalistic approach, says let's look to the text of the Constitution. Let's be very rigid about it. And that helps you perhaps in a case like Youngstown where it's really easy. There is no power to remove property or to seize property. But then we have a case like Morrison, which is our decision for today, where there is no clearly enumerated power of removal. But it's something presidents have done for a very long time. Right? So under the Black approach, maybe the president doesn't have the power to remove. Right? So that's one approach, right? The Black approach. Then we have, I'll come down to Josh, we have the other opinion, the concurrence from Justice Jackson. Right? That was one we put a lot of effort into. How did Justice Jackson understand the separation of powers? How would you characterize his approach?
He had the 3 tiers?
Okay, good, but 3 tiers, all that stuff's good, but would you describe Justice Jackson as very rigid and formalistic?
No.
Okay, how would you describe Justice Jackson's approach?
It was more adaptive.
Okay, good. I like that word. What do you mean adaptive? Just spell it out a little bit more. You're on the right track.
He would evolve, basically like.
Hannah, you want to think of a word maybe to describe the Jackson approach? How would you just? Well, what did Justice Jackson look to? Was he looking to the text of the Constitution?
The only thing I have for Jackson says can't have punishment for crimes based solely on race.
You're in the wrong case. That's Korematsu.
That's all I have.
Suresh, I think you had a point you want to raise?
Yeah, he is more interested in case by case, and he wants to look at the executive power that comes from Article 3 versus the powers the Congress gives them through Article 1. Those are going to be like his first zone, and then the second zone, he's more.
You're right, but just Nick.
Functionalist?
Functionalist, yeah, that's what I'm looking for. Very good. Yeah, functionalist is kind of like the opposite of formalist. They're not exactly the opposites, but they're more or less mirror images, right? Whereas Justice Black is saying, look, let's be very strict here, right? Let's look at the text of the Constitution, and if our answer is in the text of the Constitution, it's easy. And if it's not, then the answer is no, right? You can't do it. And then you have Justice Jackson, who had worked as a lawyer in the executive branch. He had been the Attorney General for President Roosevelt. Justice Jackson said, let's be more functionalist, maybe pragmatic. You know that word, pragmatic, right? Maybe realistic, right? If you want to use that, you want to use another word, realistic, right? Let's be realistic here, right? Let's try to assess a situation on a case-by-case basis, what Suresh said a minute ago, right? Case by case, not like put down a bright line rule. These are two very different approaches to the separation of powers. In Youngstown, I think they led to the same answer because in Youngstown it's really, well, I think at least obvious, but the president couldn't do what he did, right? But then you have other cases where it's not so obvious. And in those other cases where it's not so obvious, these two philosophies make a big difference. Yeah, Tanner?
So, I have a quick question.
Please.
Why is there not an objective view on how to apply
Oh boy. Oh boy. This is, oh, he's not here. Who asked the question last week? He sits over there. Yeah, Nick. Yeah, oh, he's not here, but see, I know people sit. I don't always know their names, but I know exactly where you sit. If I see you outside of class, I may not recognize you because you're not in the right place, but I know exactly where everyone sits, which is why it's a damnedest thing. I'll remember, I met a student from mine. She was in my class in 2014. I cannot remember her name, but she sat right there. It was a damnedest thing. I figured her name out eventually of the conversation about it. You sat right there in my property class, or ConLaw class. Anyway, but Tanner asked, I think, a good question. Tanner asks, why is there no single, I think he's word objective? Right. Why is there no objective way of reading the Constitution? I think Nick over there asked a similar question a week or two ago. I'm not going to sugarcoat it for you, right? Justice Black was a very smart justice. Justice Jackson was a very smart justice, right? I think they both approached their jobs in good faith. And I think they both approached their jobs very differently based on their, what you might call judicial philosophy. And it's not politics. They were both New Deal Democrats, right? This was not like a right-winger and a left-winger. It's not like Breyer and Scalia, maybe. These are people who came to the world in very different ways, right? Black was a former Klansman from Alabama and a U.S. Senator, right? Jackson was an attorney general who went to law school in upstate New York, never graduated, right? They were very different people. I can't tell you why someone adopts one philosophy or the other. It's not within my competency. But what I can at least tell you is that these justices do try to articulate their philosophies. And Youngstown puts philosophies clear as day for everyone to see. Right? I think the Noel Canning decision between Breyer and Scalia, they go back and forth, they lay it on the table, whatever they think they put out there. Right? I think when you look at Scalia's dissent in Morrison, he lays it out as clear as he can. And that's all I can do for you. I can tell you what these philosophies are. Wouldn't it be wonderful if everyone agreed? Sure, but that will never happen, right? People don't agree. I mean, even this class, about 40 of you here, maybe 30 of you here today, right? Try to agree on anything among the 30 of you, right? Any issue that comes up, you probably have 25 opinions for 25 people. I think that's part of human nature. Now, you're asking, but Josh, I'm in a class, right? Don't have to write an exam. Yeah, you do, right? So the best I can give you, right, if you want to actually ace this class, is understand these sorts of philosophies and how these justices tick. You don't need to know why they do it. You don't need to know why they don't do it one way or the other. It's not fair to ask you, but just know what they do, and I'll be happy. That was totally unsatisfying, wasn't it?
Yeah.
I know. I'm sorry. I told you I wouldn't sugarcoat it. There's no good answer. But again, it's not only political. Again, these are both Roosevelt appointees. They're both New Deal Democrats, but just had very different approaches to interpreting the Constitution. And that's how it goes. Yes, sir.
I have a follow-up question.
Please.
How do we know which justice is right?
Oh boy. Well, let me ask you a question, Suresh. Nick, you stole my answer.
Oh, sorry.
Just raise your hand if you want to talk. Suresh, is the majority always going to be right? I don't think so. We can do some cases where the majority did not do such a good job. You look at Korematsu maybe, or Dred Scott, you go down the list, right? The mere fact that 5 lawyers, and I use that term deliberately, right? The mere fact that 5 lawyers reach the same conclusion does not mean that they have the best answer, right? Now again, I disagree with almost every Supreme Court decision. I always find something to pick and nit on, and that's my life. But in your book, you have all the sorts of controversial cases, right? All the 5-4s. Would it surprise you if I told you that almost half of the Supreme Court's dockets are unanimous? Almost half the cases the court decides every year are 9-0, 9-0. You never hear about them because they're not very interesting, right? They're not very relevant. Cases on tax, cases on trade, cases on business transactions, stuff that I personally don't find very interesting. But they're all 9-0. And how can it be that Ruth Ginsburg and Nino Scalia agree on a tax question? Well, for some cases, there's an easy answer, right? There's a right answer, right? There's a right answer to a question. But man, a case like these, like Youngstown, they don't agree very much, right? There's a lot of going back and forth, and I think that's an easier case. You have cases like Noel Canning, which was basically 9-0, but more or less was 5-4, and the justice split on a very sharp question about whether the president can make these sorts of appointments. So I think, look, you ask a good question. I think, Tanner, you ask a good question. These are the questions that make ConLaw different from the other classes, right? In most other classes, you don't really have to read dissents. Maybe every now and then you'll have one, but they're not really that important. Here, the dissents are often just as important as the majority opinion, or the concurrence is just as important as the majority opinion. In my property case book, how many dissents do you have to read? 2, 3? Right? There just aren't many because people tend to agree on property issues, which is why I like teaching property. There are answers that are clear, right? With a question on future interest, there's a right answer, and I can tell you what the right answer is every single time. There's no debating. It's not like, what did Justice Kennedy have for breakfast today, right? That's not part of the like that's no longer relevant, thank God. But that's part of the calculus. But anyway, Nick, do you want to add anything?
No, sorry.
That's okay.
Be mumbling.
Yeah, no, I know, and I have very good hearing too. It's a blessing and a curse. So whenever you start whispering, I probably hear you. You think I don't, but I do. You're whispering an answer to your neighbor. All right, but Black and Jackson, again, they're both New Deal Democrats, both Roosevelt appointees, but they view the world in very different fashions. And oh, by the way, they hated each other, right? On the court, they would fight, they would bicker. Jackson wanted to be Chief Justice, and there were allegations he had an affair, and I think I mentioned he died in his secretary's apartment. So the characters, right? They had stuff going on, but Jackson and Black hated each other, right? But there was another opinion I want to talk about from Youngstown, which was that of Justice Frankfurter. Who am I up to? I think Ethan. I think you're next.
Yes, sir.
Yeah, Ethan, can you remind us what Justice Frankfurter talked about in Youngstown, please?
So his opinion was basically that executive past practice could have
Yeah.
lost.
Yeah, and then just give me a few words. What does that mean, executive practice and gloss? What does that phrase mean, sir?
Basically, a systematic, unbroken
Very good.
executive practice would kind of gloss the Constitution or add.
Yeah,
or
yeah. Very good. Thank you, Ethan. Frankfurter was also very much into functionalism, right? Just with a different kind of blend. Jackson was more, let's do it in a case-by-case scenario, right? Frankfurter is like, well, let's be a little bit more specific, right? Let's look to see if there's some sort of unbroken, systematic practice, right? That is, if all these presidents have done something and Congress never really objected, then that practice means that maybe the president has that power. In other words, if the other two branches are okay with something, then maybe the court should just go along with it. That makes sense, right? Which, this is Frankfurter's kind of functionalist, but a little bit different. And by the way, Frankfurter was the children of Austrian Jewish immigrants. He was a law professor at Harvard, graduated first in his class. Also a New Deal Democrat. Completely hated Black and Jackson. They hated each other, right? They saw things completely differently. These three, and also Justice Douglas, who I don't really think is relevant here, but they call these guys the four scorpions in a bottle, right? If you put scorpions in a bottle, they basically kill each other, right? That's what they call these four. They call them scorpions in a bottle because they hated each other so much. They just had such completely different understandings of the world. And they were all New Deal Democrats, right? That's why it's a little bit easier for me to do this than today. It's basically, the Republican appointed justice go this way, and the Democrat here they were Roosevelt noms, and they all hated each other. Yeah. God, Justice Douglas. Yes, sir.
Could it also show the different times of President Roosevelt's
Yeah.
appointments?
Very good. Yeah, Roosevelt made these four appointees with a New Deal in mind, right? He didn't really have sort of war powers in World War II in his mind yet. It was much earlier, in 34, 35, 36, 37, 38, and then we didn't get into the war till 41, so almost towards the end of his presidency. But good question, sir. All right, where are we? Yes, Matthew. Oh, you're volunteering next. Okay, you're not.
I was like, oh, I missed it.
You're not. You're very good. Thank you. All right, I will give you a question in a minute. I promise. Okay. So everyone get these different. Oh, is that a question? Okay. So everyone get these general sort of philosophies, right, of how the justices approach separation of powers. You will see these same sort of philosophies repeat themselves over and over again, right? So if I give you on the exam like a separation of powers question, just keep in mind these three names. Douglas, I'll just delete Douglas, so you don't get confused. But these three names I think are pretty important. And there's sorts of philosophies of how they go about the world kind of pop up over and over again. Okay? Make sense? All right. Let's move on to the first case. A very important case. A really important case. Well, not so much anymore. But when the Mueller stuff was going on, it was much more relevant. Not so much now. Okay. All right. So the first case we have involves the appointment power. Okay? So we have Article 3 of the Constitution. which is called the Appointments Clause. And it says, the President shall nominate and by and with the advice and consent of the Senate shall appoint ambassadors, public ministers, and consuls, judges of the Supreme Court, and all other officers of the United States whose appointments are not herein otherwise provided for and which be established by law. But the Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of department. Okay? And then you have this next provision that says the President shall have the power to fill up all vacancies that may happen during the recess of the Senate. Okay. This is the provision for our second case, Noel Canning. I want to just focus on this first paragraph first. So, Matthew, why is it important as a general matter that the President gets to pick who works for him, as a general matter? In any organization, right? Why should a person be able to pick who gets to work for him?
So that they can run their, whatever it is they're trying to run as efficiently as possible and in line
Yeah.
with the goals that they have set out.
Yeah, it makes sense, right? If you're the leader of an organization, whether a company or the military or the United States of America, you want people who can carry out your vision, right? You don't want people working for you who are going to frustrate you, right? If you ever had any sort of coworkers who are dragging their feet, you know how that works. Or maybe more relevant, if you ever had a group project, yes, where one person wasn't carrying his or her weight, it can drag things out, right? Now, but Tanner, why do you think the framers of the Constitution required the consent of the Senate, the advice and consent of the Senate, which is by the way, it's a majority vote, 50%, right? 51% actually, right? Why do you think the framers of the Constitution required a majority vote of the Senate for the President to pick his, what are called principal officers?
Probably to allow just like the people to have like a voice in the like appointments, so that way that the President couldn't try to put somebody in there that was just absolutely crazy or something.
Well, do you think that the Senate was worried about the President picking, nut jobs for his positions?
Probably not, but
Okay, so this was kind of like an emergency, like if he picks a nut job, he can kind of block him.
yeah.
Now, what happens, Natalia? Let me ask you a question. What happens if let's say the Senate is not very happy with the President, and they say, you know what? We don't have the votes to impeach you, but we're going to punish you. We're going to block all of your appointments. You can be by yourself in the White House. Could Congress do that?
Yes.
Yeah, they could. Now, perhaps the President might make a recess appointment, which is a topic we'll do in the second case. But why would it be problematic for the Senate to block all the President's appointments? Why might that actually be really a big issue?
Because then they end up having more power on the President.
Yeah. And then what will the President be able to do to Natalia?
Well, make recess appointments.
No, but what if the President has basically no one around him? All he can do is tweet, right? No, if the President has look at this photograph. If the President's no one around him, they took down the tweet because of Nickelback gave him they took down the damn tweet because of Nickelback. You don't even remember Nickelback. You weren't even alive for it. God, it was a really bad band in the early 2000s. It was just terrible. Sorry, Natalia. What's the President gonna do if he's just alone in the White House, nothing but his phone? What can he do at that point? Nothing, right? Yeah, exactly. The President has an obligation, right? It's called the Take Care Clause, which is a provision that I think is very important, but people only started looking at the last 2.5 years. It says that the President shall take care that the laws are faithfully executed. And the very nature of that suggests that the President's supervising, right? The President doesn't do anything himself, and I don't mean just any President in particular, right? Presidents give orders. They say, Secretary of Defense, go do this. Secretary of State, go do that, right? Secretary of Commerce, you go do this, right? He gives orders to his principal officers to go do stuff, right? And he has to make sure that the law is being executed faithfully, right? It's a supervisory duty. But the president doesn't have anyone around him. He can't make sure the laws are executed. The president can't do stuff by himself. He's sitting in the White House, right? He can't go around the world, right? If the Senate refuses to confirm any of his people, he can't execute the laws at all. So you see how the appointment power is closely linked to the power of faithful execution, right? If the president can't have his people around him to do his bidding, so to speak, he can't execute the laws. Okay. But the framers recognize this, so you only need a majority vote in the Senate to appoint people. Now, David, let me ask you a follow-up question. What happens if the president appoints someone and it's not working out, right? President appoints someone, the Senate approves him, and it's just not working, right? That the person in office is maybe he's lazy, right? Maybe he's corrupt. Maybe he's dishonest. It's just not working. Or maybe the guy is honest but disagrees with the president's agenda. He says, you know what, Mr. President, you want to do X? I don't think it's a good idea. I want to do Y, so I'm going to do Y now. What is the impact of that sort of conflict between the president and his workers, his subordinates?
I think that it would prevent the president from trying to get the work done that he set out to do in his office.
Right. And so constitutionally, what is that impeding? What is that infringing upon? What would we say that the inability to have the workers do what he needs, what does that violate? What does that run into conflict with?
Probably to take care of policy.
I think so, right? Why does having an insubordinate worker interfere with the president's ability to execute the law?
Because he doesn't have anybody that he can count on.
Yeah, I think that's right. I think David said it well. Generally, the idea is if the president has the duty to faithfully execute the laws, that means he needs people who are able to do it for him. And if he has someone in office who's not getting the job done, he can't faithfully execute the law. So Nolan, what does the president do then if he has some subordinate who's not letting him execute the law? What does he do to that subordinate?
Fire?
You can fire him, right? And in any company, right, if you have a worker who's not doing the job right, you can them, right? You get rid of him. But Nolan, what's the problem constitutionally with removal, right? The removal power. Why is that such a huge debate or a huge conflict within the Constitution?
I guess because it doesn't expressly say anything about firing people.
The Constitution, my friends, is silent. Right? The Constitution is silent about whether the president's the power to remove people. It says nothing, right? The Constitution says you can appoint with the advice and consent of the Senate, but the Constitution says nothing about whether you can fire. Now, maybe one answer is, well, if you can appoint with the consent of the Senate, you need the Senate's consent to fire. In other words, if the Senate says, no, just keep this guy in office, you're stuck with him. This is not an easy question. And I go back to Tanner's question, why can't there be an objective way of reading the Constitution? In 1789, right, the year the Constitution was ratified, there was a debate in Congress on this exact question. Does the president have removal power? The very year the Constitution was ratified, right, the same people who drafted the document had a disagreement about whether the Senate had a role in removal. There was a debate in Congress in 1789. This debate is called the Decision of 1789. I know it's not a very creative name. That's what it's called, right? The Decision of 1789. And I'll summarize a few. It's a long story, but I'll summarize a few. There was a bill that considered whether the Senate had a role in the removal process. The House of Representatives voted that the president could fire on his own. Didn't need the permission of the Senate. And James Madison, for one, encouraged that bill, that the president, George Washington, could fire a certain officer. But then the Senate divided. There were some people in the Senate who agreed with Madison that the president could fire whomever he wanted. And there were other people in the Senate who thought, no, no, no. The Senate has a role. The Senate has to consent to a termination. Guess what happened? The vote tied in the Senate. The very first Senate tied on the question of whether the president has this power to remove. And who cast the vote when you have a tie? The vice president. So John Adams did one. The only thing that ever actually mattered as vice president, he broke the tie. And he sided with the House of Representatives. And Vice President Adams said, yes, the president has this power. So this wasn't a court case, but this was an executive practice in which the U.S. Congress very narrowly, by a single vote, endorsed the removal power. How would Justice Frankfurter see this? Well, it's a practice. It was pretty divided. Is this a clear, unbroken practice?
Shouldn't the vice president have recused himself?
Oh, what a good question. Yeah. This was an office that this affected his boss, didn't it? So I don't think it's a good question, but I don't think members of Congress and at least the vice president sitting as the president of the Senate have recusal standards, right? Very often, members of Congress vote in their own self-interest, right? They'll vote to appropriate some funding in their district, right? They'll do something that benefits their constituencies. In fact, most members of government vote to help their own constituency. So I don't think that the vice president would have to recuse the same way a judge would, but it's a good thought. There have been very few tie-breaking votes in American history. You can Google it, but the number is pretty small. I think there have been more in the current administration than in some time. We've actually had tie-breaking votes for judges being appointed, which I think that's also quite novel. Okay. So questions on that so far. All right. So we have the decision of 1789. The issue sort of just lingered for about 70 years or so, right? It didn't really come up until the Civil War, right? You'll recall that after the Civil War was concluded, President Abraham Lincoln was assassinated. He was shot by John Wilkes Booth in Ford's Theater in Washington, D.C. He died shortly thereafter. At that point, the vice president, Andrew Johnson, became the president. Lincoln and Johnson did not agree on things. Lincoln was very much in favor of Reconstruction, right? The idea of basically rebuilding the South to eradicate the remainders of slavery. He was a very, very big abolitionist. Johnson wasn't. Johnson was a Southern Democrat from Tennessee. And he did not favor the federal government reconstructing the South. He didn't. He wanted to take a much more slow and gradual process, if you can call it that. What happened? When Lincoln was shot, Lincoln had his cabinet in place, his officers. Right, he had his officers in place. And Andrew Johnson inherited Lincoln's cabinet. Now, you might say, well, shouldn't Johnson get to be able to pick his own people? In theory, yes. So Johnson tried to fire Lincoln's guys. One of them was named Edwin Stanton, S-T-A-N-T-O-N, Edwin Stanton, who was a Secretary of War under Lincoln. Okay, he was a Secretary of War. And Stanton did not like Johnson. They did not agree on anything. So Johnson goes to Stanton, you're fired. Get out of here, scram, right? You're fired. I want to put my own guy in. That didn't quite work out because Congress had enacted a law called the Tenure of Office Act. The Tenure of Office Act. What was the Tenure of Office Act? In order to fire this official, you needed consent of the Senate. Okay. in order to remove an officer, you need the consent of the Senate. Everyone understand what I'm saying? Okay. This was a dramatic scene. Johnson says, you're fired. Right? Johnson says, you're fired. Stanton says, no, you can't fire me. The law doesn't allow you to fire me. I just want you to imagine the scene, right? President says, you're fired. Secretary says, no, you can't get rid of me. And there were not the votes in the Senate to remove him either, because he was popular. What does Stanton do? I'm not joking. He locked himself in his office. I'm not making this. I'm serious. This actually happens. This is true history. The guy locked himself in his office and basically said, I am not going to leave. Now, this went on for some time. Eventually, he left, right? Eventually, he sort of left his office. So the crisis sort of diffused. But these were things like, you're fired. No, I'm not leaving. And he basically told his men, don't let the president, people come in here. Right? Remember we talked about Merriman, where Chief Justice Taney sent his poor marshal to the fort to arrest the general of the army. This is similar, right? Where the president says, I want to remove you. And the guy's like, I'm not going anywhere. Now, did Stanton go to court and sue for his salary? No, that's not what happened. That's how they did things back then, right? Instead, the House voted to impeach the president. Right? This was the first impeachment of a U.S. president. The very first impeachment of a U.S. president. And what was the ground for impeachment? There were a bunch of things, but the primary one was that President Johnson violated the Tenure of Office Act. That President Johnson violated the Tenure of Office Act by firing Stanton without seeking Senate approval. Everyone understand what's going on, right? The Senate said, this law says you need approval. You didn't seek it. We're going to impeach you. Is your hand up, Ellen? Okay, so what happened? Well, you know impeachment's a two-step process, right? You should know this now for sure. The first step is that the House of Representatives sends out tweets. No, they introduce articles of impeachment, right? They introduced articles of impeachment saying, we are charging the president with so-and-so, with these offenses, right? To impeach in the House, you just need a simple majority, right? It's similar to a grand jury indictment, if you want to think of it that way, right? They're just saying, is there enough evidence to proceed? Yes, the House impeaches. The second step is what's called the Senate trial, right? The Senate actually holds a trial, and the Chief Justice presides during that trial. Chief Justice Salmon Chase, our guy, right? He presided during the Johnson impeachment trial. The Senate needs a 2/3 vote to convict, right? So it's not a simple majority, it's 2/3 to convict. And upon conviction, the president's removed from office, right? The president is removed from office. At the time, I don't think there was actually a vice president, so it would have been a little bit dicey who became the president. I've been the Speaker of the House, or so, I can't remember the exact chain, but it would have been dicey. So basically, when talking about conflict of interest, the Congress is basically voting to impeach one of their own guys in the White House. Just think about that for a minute, right? You want to talk about conflict of interest, right? And again, the purpose of the trial was largely on the Tenure of Office Act, right? And then Johnson said, no, you can't remove me. I have the power, the constitutional power to remove officers. That the Tenure of Office Act is unconstitutional. Again, Johnson said, you can't impeach me. The Constitution gives me the power to fire these people. Go look at the decision of 1789 and George Washington. James Madison, right? They won that debate. John Adams, 1 vote, right? They won it by 1 vote. Johnson said, you can't impeach me because this statute's unconstitutional. The Tenure of Office Act is void. All right, go with me. Fast forward a little bit more. The trial goes to a vote. Johnson is acquitted by a single vote. They missed removal by 1 vote. 1 vote, again, 1 vote. Now, there are a lot of reasons why they didn't remove Johnson. They thought it'd be too divisive, it'd be bad for the country to have removing a president in office. Just there was so much stuff going on, just have an election, vote him out of office in a couple years. Which makes sense, right? But that didn't resolve the constitutional question. Who was right? Was Congress right? They could limit the removal power? Or was the president right? Was the president right that he has the constitutional authority to fire whomever he wants. Yes, sir.
Wouldn't it be that, in a way, we could look at it that Congress is coming back to the decision in 1789 and deciding that decision?
Well, I mean, it's a very good question, right? How do we treat Johnson's acquittal, right? Is Johnson's acquittal a reflection on the law, or maybe you thought it would just be a bad idea to throw the president off office, but not a judgment of the Constitution? Now, I actually tend to think that the decision of 1789 was right and that the Johnson trial was wrong, but there's no good way of reading this answer, right? Who is right, who is wrong? This is your question from the start of class, right? The fact that Johnson missed out conviction by a single vote, does that mean that the other side was right? Do you need a 2/3 vote to convict in court? I mean, these are hard questions. Okay. So anyway, the impeachment of Johnson did not resolve this question. I got one more case to talk about, then we'll get to Morrison. This is a lot of build-up, I'm sorry, but there's a lot of history that I have to push you through. Yes, sir, David.
Is it the tenure of office act or the 10-year of office act?
Tenure.
Okay, that's what I figured out.
I'm sorry, it's not 10-year, it's tenure. Sorry, I should have spelled that out. But tenure of office, like that. It wasn't a 10-year position, it was tenure. Right? I have tenure as a professor, which is why I say where the hell I want, right? I did it before I had tenure anyway. There was a story, oh my God. This professor at Case Western is 94 years old. 92 years old, he's still teaching. Angela, you say hand up?
So since they said that, since they didn't impeach him, did that make this act unconstitutional?
I think you can look at two ways, right? So the one way you can look at it is because he was not removed, that means Johnson was correct about the Constitution and that this law is unconstitutional, right? The second way is Johnson was removed because of political reasons and there wasn't a solid consensus on the constitutional question. So I think it can be read either way. But let me. This story is amazing. There's a professor at Case Western in Cleveland. He's 92 years old. He's still teaching. So cute, right? He's 92. He's still teaching. Teaches income tax. My goodness, right? I can't teach that, right? He's been teaching since 1968, which is like probably some of your parents were born around that time. It's remarkable. He's still going to school 4 days a week. I saw this story, it made me very happy. My goal, you're gonna laugh. It's to teach till the tricentennial in 2076. I'll be 94. We'll see if I make it. You'll all be here for the alumni reunion, but serious. South Texas is celebrating its 100th anniversary in a couple of years, right? So I was here for the 90th, but 100th in a couple of years, so maybe 200 years I'll be here for that. Anyway, back to ConLaw. But I think Angela's question, I think, is well stated, right? What do we take away from this impeachment? Does it mean that Johnson was right about the Constitution, about this removal power? Or does it mean that this was just politics? Impeachment is political, so we don't have an answer. But the Supreme Court would weigh on this case in, oh God, what year is it? Well, you read my mind. Thank you. 1926, right? I was about to control F, but you beat me to it, right? So a case called Humphrey's Executor, 1926. Thank you for that. I don't know who said it. I just heard a voice shout out, like the omniscient voice from above, right? 1926, Humphrey's Executor. This was a strange case because the guy died in the middle, right? That's why it's called Humphrey's Executor, right? If you have a case.
1935.
Yeah, I'm thinking about Myers.
Oh, let's do Myers. Fine. Okay. Myers was 26, and Humphrey's Executor was 35. Fine. All right. We'll do everyone. Okay, that's fine. We'll do those. Okay. We'll do another case. Thank you. So. He read my mind, right? But you read it too well. Let's look at Myers first then. Okay, 1926. This was a case decided by Chief Justice Taft. And Chief Justice Taft has a unique honor. He's the only person who's both the president and the Chief Justice, right? He was a remarkable guy. He was also ginormous. I think I told you this, but he was so large, he once broke a horse's ankles. The guy was riding a horse, and the horse's ankles actually broke because he was so heavy. Yeah.
He was also stuck in a bathtub in the White House.
Yeah, that's true. Yeah, the story goes that apparently some animal rights activist sent him a camel, said ride this instead. But anyway, he was brilliant, and he loved being a judge. That's what he loved. So we had a case called Meyer, Myers versus United States from 1920. Thank you for the year, 1926. What was Myers about? You had a guy who was a fairly, I don't want to say insignificant, that's mean, but he was a postmaster, right? He worked for the Postal Service. And his job was appointed by the president and confirmed by the Senate. Congress enacted protection for his position, right? And the protection said, you can't be fired unless you have the consent of the Senate, right? So in other words, the same sort of tenure of office act that protected the Secretary of War, right? I'm sorry, it's M-Y-E-R, I spelled it wrong. The same sort of a protection that protected Stanton also protected his postmaster, okay? President, I think it was Wilson, came in, and Wilson said, thank you very much for your services. Your services are no longer needed, you're fired. I won't put my own person in there. Now, do you think Wilson actually cared who the postmaster was? No, of course not. This was what we call patronage, right? Where you put your own people in there to give your friends jobs. We don't know this. I know how this works, right? So Wilson just wanted his own guy in there. It wasn't about politics. Like, thank you for delivering the mail, sir. You've been very good. I want my own person in this office. Okay. Meyer then goes to court and sues. Says, no, 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 you can't do this. I have protection for my job. I have protection of my tenure. And Chief Justice Taft decided this question. And Chief Justice Taft said, you know what? George Washington was right. You know what? The decision of 1789 was right. And you know what? Andrew Johnson was right. The impeachers were wrong, right? And Taft goes through this long opinion that says that the Constitution gives the president the power of removal. In other words, this is, Angela, your question a minute ago, Taft says that the impeachment was wrong, that they were wrong, and the correct vision of the Constitution was from Andrew Johnson and George Washington with 1789 decision. Everyone get that? Now, is Taft right? I happen to think he is, but this is not clear, right? There's no text to describe one or the other. But Taft says, look, you have all these presidents. You have George Washington, you have Andrew Johnson doing this. Therefore, this president has the power of removal, and it's absolute. It's an absolute power of removal, right? Taft writes that if the president can't have power of removal, he can't execute the laws, he can't pick his people around him. Okay? That's Meyer versus United States, 1926. Thank you. But that wasn't the end of the story, because about a decade later, in 1935, we have another case called Humphrey's Executor. Humphrey's was a weird case. So I can resume my spiel, right? And the reason why it's called Humphrey's Executor is because the guy died in the middle of the case. Who was Humphrey? Humphrey was appointed to the Federal Trade Commission, right? It's one of these 5-member agencies where 3 members are appointed from the president's political party and then 2 members are appointed from the opposite political party, kind of like the NLRB, right, where it's 3 and 2. So there's always a majority of people from the president's party, and they vote on stuff. President Roosevelt came into office, and he said to Mr. Humphrey, thank you for your services. You are no longer needed. He was appointed by Hoover, who was a Republican. And Humphrey's like, yeah, no, thank you. I'm staying in my office, right? And Roosevelt's like, well, you're fired. Now, Roosevelt didn't give a reason why. He said, your service is not needed, right? He didn't say, you're not doing a good job, or you're dishonest, or even I disagree with this. Nope. Don't need your services anymore, thank you. Roosevelt fires him. At that point, Humphrey sues for his salary, saying, look, I had a guaranteed job. Where's my salary, right? He goes to court. At some point, Humphrey died. So his estate continued the lawsuit, which is why it's called Humphrey's Executor. Now, I had a student years ago who said, did Roosevelt have him killed? And I think I made a joke about this, right? I was like, oh, yeah, I guess Roosevelt had him offed, right? Internet. Someone was watching my videos and actually requested a copy of his death certificate, which I have in my office. You can come look at it if you want some time. He died of some sort of coronary, some sort of heart attack. So they say, right? But I'm joking. But he was murdered in a dark alley in Washington. No, that wasn't what happened. He had some sort of heart attack or some sort of coronary. Anyway, I think I blogged a picture of it at the time. But the guy still, he died, and this goes to the court. Now, Humphrey's executors have a weird opinion, and it's talked about in Morrison v. Olson, right? Humphrey's executors seem to say that when you have these principal officers, right? Principal officers like ambassadors, judges, and other officers of the United States, these very important people, the president can fire them at will. But you have these other types of positions that are different, right? The commissioners of the FTC were not quite executive. They were, the phrase used was quasi-judicial and quasi-legislative. God, I forget which one it is. Quasi-judicial and quasi-legislative. What the hell does that mean? Well, administrative agencies are kind of weird. They don't just execute the laws, they also basically make law. They write regulations which have the force of law. They can also adjudicate cases, decide cases. Okay? And the court has this sort of weird opinion that, well, because these are not purely executive, they're quasi-judicial, quasi-legislative, that means that, you know, the president can't remove them at will, right? So you have this decision. You have Meyer saying, yeah, the president can fire the postmaster. Then you have Humphrey saying, well, they can't fire these sort of quasi-judicial, quasi-legislative officials. Humphreys was largely seen as a rebuke of FDR. This was 1935. We're not at 36 yet. And the court was still ruling against Roosevelt. So I don't think Humphreys was correct in any sense. I think it was mostly saying, Roosevelt, stop it. You're being obnoxious, right? Stop trying to fire these people. But that was the law. Until we get to Morrison v. Olson, which more or less overrules Humphrey, right? That's why I have to do this entire hour-long spiel to get you to Morrison, right? There's a lot of history in Morrison, which the court just sort of sweeps aside. They sort of sweep it aside. Whew, that was a lot. Okay, I'm not done yet. This is one we're lecturing classes, I think, of the semester because there's so much history. I used to assign Humphreys and Myers. It's really long. And so now I assign Morrison. But I used to assign all those opinions, which I think maybe I won't, but that's why I give you this history. Okay. Yes, sir. Please.
And this is going back all the way to the impeachment of Johnson.
Yeah.
It's kind of sidetracking. So,
I'll put you back on track if I need to.
let's say the radical Republicans had gotten that 6-year vote.
Yeah, that last, they need to vote.
And
Yeah.
Just and President Johnson took Secretary Stanton's lead and
Locked himself in the office.
Yes, and refused to remove himself. What would happen?
This was my final exam question a couple of years ago, but a little bit different. So Soros is asking, what happens if the president's removed and the president refuses to leave office, which I guess is a non frivolous question. My question a couple of years ago was different, right? Let's say the president is removed from office and he disagrees with the grounds for removal. And then he goes to sue for a salary, right? And he goes to court saying, look, I'm due a salary. My salary is fixed by the Constitution. Where's my salary? And then the courts rule, yeah, get your salary. That means you're still president. So my final exam question was actually, if Chief Justice Chase had this case, should he order the return of the president's salary, which basically means he's still the lawful president. We've had a good run in this country where we've had peaceful transitions of power for 200 years and times far worse than our current state. So I think it's unrealistic to expect that to happen. That's all I can give you. But in other countries, you don't have peaceful transfers of power. And you do have leaders who lock themselves in office and put up guards around their doors. And you have leaders who send military to dispatch and assassinate and take down leaders in coups. So it happens in the world. Thankfully not here, but it happens. Yeah. Yeah.
For that salary question, could you not just sue like on a contract basis?
That was the setup. He went to the Court of Claims, which is where you basically sue the government for breaching contract. That was the setup of the question, right? I mean, it's generally the courts don't have review over impeachment, and the Supreme Court said that we don't decide the specifics of impeachment, right? That's not for us to decide. But in theory, some people have argued that the salary might be one way around it. Alan Dershowitz, if you watch cable news, he wrote about this in his book, where I got the idea from. Dershowitz seemed to suggest that if the Senate impeaches on an unconstitutional ground, right? For example, let's say the Senate had tried to impeach the president for firing James Comey, right? And Trump says, no, the Constitution gives me the power to fire Comey. That, in theory, would be an improper impeachment. Would the courts have any power of reviewing or even checking that? And of course, Chief Justice Roberts presides at that impeachment. Could he then cast a vote? Now, I got that question yesterday. I did a Supreme Court preview in D.C. yesterday on this exact question. The question was, if Chief Justice Roberts presides in an impeachment trial, would he then have to recuse any cases touching on the issues concerning impeachment? Which is a good question. I wouldn't miss his vote just as well. But it comes up. Chief Justice Rehnquist, when he was presiding the impeachment, he did this crazy thing where he had his robe and he put these 3 gold stripes on his robe. Why? He saw some opera where the character in the opera was a judge, put stripes on his robe, so he did it. He's insane, right? he was kind of eccentric. He was kind of weird. He was an odd guy. And then there's a funny after story. The Smithsonian, the museum in Washington, wanted him to donate the robe. He actually sent a letter saying, can I get a tax deduction for this, or else can you pay me for the value of the robe? And they actually gave him a tax credit for almost $30,000, which is the value of the robe for the impeachment. He was an odd duck, Rehnquist. He was a really weird. Again, he proposed to O'Connor by letter from the Supreme Court. He got turned down. So he was an odd duck. Very, very, very odd guy. Yeah, anyway. Got to brush up on our impeachment stuff, right? Yeah. All right. Questions so far? All right, let's talk about Nixon now. A natural segue, right? Morrison v. Olson was decided in 1988, but the case really began much earlier, during the presidency of Richard Nixon. And I want to walk through some of the history here. In 1972, Nixon was running for re-election. The committee to re-elect the president, which had the nickname of CREEP, which is just bizarre, but the committee to re-elect the president made a decision which still is unclear why. They sent a bunch of burglars to break into the headquarters of the Democratic Convention, the DNC. It was at the Watergate Hotel, which is in Washington, D.C. Actually, funny, guess who lives there now? Ginsburg. Ruth Ginsburg lives in the Watergate Hotel. Now it's an apartment complex, but I've been there. It's really old and danky. Maybe her apartment's nicer, but it was really, it looked like it was built in the 60s. They broke in. It's not even clear what they were doing. But at some point, the campaign tried to keep the burglars silent. They tried to pay them so they wouldn't, talk to the cops. Nixon, as best as we can tell, didn't know about the break-in at the time, but he learned about it later. He did know about the cover-up, and Nixon was involved in trying to get money, moved around to pay the burglars to shut up and not talk to the cops, right? You should know this, but that's called witness tampering, right? You might call it obstruction of justice, right? You can call it different things, but you can't go and tell a witness not to testify, especially if you're bribing them. That's a no-no. Now, generally, this would have just been ignored, but for the fact that there were recordings, right? Nixon and other presidents had installed a recording system in the White House. And the way it worked is whenever it detected a voice, the tapes would start spinning, right? So it was a voice-activated recorder, right? It sounds high-tech, but, it was the 60s at tapes. It was the 70s here. All right, everyone with me. Soon this became very controversial. Okay, why was it controversial? The president was involved in a cover-up of a crime. At the time, when you had these sorts of conflicts involving the executive branch, there was a procedure to appoint a special counsel. A special counsel is a lawyer within the government who could investigate these sorts of, controversial issues. And a special counsel is appointed, and his name was Archibald Cox. This is Cox right there. At the time, the Attorney General was Elliot Richardson. So Richardson appointed Cox as a special counsel. I'm sorry, a special prosecutor. Okay? Richardson had testified during a Senate confirmation hearing that he would support the special counsel. I say special prosecutor, okay? Mueller was a special counsel. Okay. What happens next? Cox then issues a subpoena to the president demanding the White House tapes. Nixon flips out. He's like, who the hell is this guy to make any demands to me? I'm the president, right? Right? You can't tell me what to do. So then Nixon does something which was expected, right? Nixon tells Richardson to fire Cox, right? Now, Richardson knew this was coming, right? This was not a surprise. The second the subpoena was issued, Richardson knew he was going to be called upon to fire this prosecutor, and he wasn't going to do it, right? Because he had promised the Senate he's going to keep him in office. So this was kind of a setup, right? But Richardson says, okay, I resign. All right, what happens next? There's a chain of authority, right? So the next person at DOJ is called the acting attorney general, right? He steps into the office. And his name was William Ruckelshaus. Nixon goes, fire Cox. Ruckelshaus says, no, I resign. Again, this was expected. Ruckelshaus had also promised the Senate he would support the special counsel, special prosecutor. Okay? Okay. Keep in mind, Nixon could not fire Cox himself, or he maybe could have, but he didn't try, right? Nixon asked his subordinates to carry out his orders to fire Cox. All right, what happens next? The number 3 guy at the agency was now Robert Bork, who was the Solicitor General. The Solicitor General is a top U.S. Lawyer who argues for the Supreme Court. Bork had not made a similar promise to the Senate. He never pledged to support the special counsel. I keep saying special. I've been drilled by Mueller. Special prosecutor. I'm sorry. Okay, so Nixon goes, fire him, you're fired. Okay, so he's gone, right? Yes?
There's the Solicitor General appointed with advice.
Yes, but he never made the promise to the Senate. The reason why is the Senate never thought to ask the number 3 guy about this. Like, why would they, they never thought it would come down to him. Now, here's a funny story, right? Richardson and Ruckelshaus told Bork to fire the guy, right? They knew this was going to happen, right? And they told Bork, you have to do this, because if you don't do it, the entire freaking DOJ will be fired. The janitor, right? Who's left, right? You got to ask someone, right? The guy at the front desk, right? You got to ask someone. So Bork said, okay, I'm going to do it. And he knew he had the power to do it. He knew it would be unpopular, right? Another fun fact, in 1987, Reagan appointed Bork to the Supreme Court, and that nomination was defeated. Long story, but it was, I think, at least in part, maybe due to this instance. All right, so what happens next? So Cox is fired. This all went down on a Saturday night, right? All 3 of these people were fired on a Saturday night, and it became known as the Saturday Night Massacre, which I think is a great name. Even though Nixon didn't actually fire anyone, right? There were 2 resignations. Richardson and Ruckelshaus resigned. They were not fired. In fact, this is a point of privilege. It's like, you didn't fire me, I quit. It's one of those things, right? Where they didn't want to be fired. They want to be on record as having resigned. In other words, Nixon couldn't fire them because they resigned first, right? Generally, if you're in government service, if you don't like what your boss is doing, you resign. Now you just wait to be fired by Trump, then you tweet about it, right? I'm only slightly exaggerating. But back then, you would resign. That's how people would do it. I remember the day after Sally Yates was fired. She was the acting attorney general when Trump first came to office. I was on the BBC, and someone said, Nixon fired these people. I'm like, no, he didn't fire anyone. I have to correct people. It's okay. That's why I'm here. All right, so what happens next? The controversy did not die down. Bork appointed another special prosecutor, and it was Leon Jaworski. And surprise, surprise, Jaworski put a subpoena to Nixon. I mean, this is why this was also stupid, right? This was going to end. there was an end game, right? This was going to end for Nixon bad. So he just starts dragging this stuff out. So he issues a subpoena to the president, and guess what? It goes to the Supreme Court. This case is in your book. I don't assign it anymore. You can read it if you want, called United States against Nixon. And United States against Nixon considered whether the subpoena from Jaworski to the president was valid. And the Supreme Court upheld the subpoena in a decision that's, I don't know if it's right, but it was unanimous at least. Said that Nixon had to comply with the subpoena. Indeed, Nixon complied with the subpoena, right? And he turned over the tapes. That was huge, right? That the president actually turned over the tapes to comply with the Supreme Court order. At that point, the House hadn't yet impeached him, but there were impeachment proceedings going forward. By the way, who was one of the lawyers on the impeachment team? Hillary Clinton. Right? The world is flat, right? Basically, the world is flat. It's the same people just popping up over and over again. Yes, Hillary Clinton was one of the lawyers on the Nixon impeachment. Just there's nothing new in the world. Everything just sort of repeats. The House was going to impeach him. They were going to. So Nixon instead resigned from office. He stepped down. The first president to ever resign from office. Okay. So Nixon was not impeached because he knew he was going to get thrown out of office. He didn't want to go through that embarrassment. Yes, sir.
I recently heard that the House managers for the Clinton impeachment used Hillary's memo
Yep.
As a
Yep.
guidebook for impeaching her.
Yeah. Basically, in '98, when the Republicans impeached Clinton in the House, they basically used Hillary's work to impeach her husband. I'm telling you, the world is flat. It's the same thing over and over again, just different. Yeah, it's just my entire life has just been it's just a circle.
You might be using it again.
Yeah, no kidding.
For the guy who beat her.
Yeah, I mean, no kidding. I mean, just it's the world is flat, my friends. Yes.
That's exactly how I felt when I read about Justice Gorsuch's mom.
Oh, of course. Why not? I mean, why isn't it Gorsuch's mom the reason why I have Morrison against Olson? I mean, why not? I mean, that of course it's Gorsuch's mom, right? I'm telling you, you'll see this as you mature. I'll say mature is the wrong word, but as you go into the world of lawyers, it's flat. Just it's the same people over and over again. Just keep doing stuff, right? I mean, that Robert Bork was the Solicitor General, then he became denied the Supreme Court nomination. I mean, it's just, there are very few people who ever do stuff. All right, so let's move on. I'm not even at the damn case yet, right? So after Nixon's resignation, there was a bipartisan consensus that something had to be done about corruption. That something had to be done about ethics in government. And Congress enacts the Ethics in Government Act, the EIGA, the Ethics in Government Act. Was it 78? I think it's 78. The Ethics in Government Act. And the law did a lot of things, right? And I don't care about 99% of the law. I only care about one provision today, which was the Independent Counsel Statute. Okay, there's Randy. Oh yeah, this is a very famous picture of Nixon resigning. He put up his two fingers with a V, right? Now just be later losers, right? But that's how you signed off back then, right? But in response, Congress enacts the Ethics in Government Act. And this law had the independent counsel provision. All right, I'm going to stop talking now. I should talk about the damn case. I can't. There's more. The case in Morrison arose in a fairly partisan environment. Okay, so this is Ted Olson, who, of course, the Earth is flat. Ted Olson was the lead plaintiff in Morrison v. Olson. He was a Reagan administration official. He later became George W. Bush's Solicitor General, but he also argued Bush against Gore for George W. Bush. He became SG after that. Years later, he became something more of a not quite conservative, and he argued one of the gay marriage cases in favor of gay marriage. And actually, in a couple weeks, he's arguing in favor of the Dreamers in the DACA case. So again, the world is flat. It's the same people just popping up in different points. But Ted Olson was the plaintiff. He time he worked in the Department of Justice, and he gave some advice to Anne Burford Gorsuch, who is Justice Gorsuch's mom. Justice Gorsuch's mom probably lied to Congress. Probably. Maybe not. Or maybe it was circumspect with the truth. You know, we can say whatever you want, but she said stuff that, you know, maybe wasn't entirely accurate, and, you know, we'll be friends about that. She eventually had to resign. She stepped down from office. Whatever. Subsequently, the House went on this lengthy investigation of Olson. And the question is whether he had either misled Congress or maybe had given Gorsuch some bad advice. The facts of that dispute I don't actually care about really much. But what mattered is the House made a recommendation to the Attorney General to appoint a special independent counsel. Okay? Right? The House representatives told the Attorney General that we recommend that you should investigate this further, Mr. Olson. Okay, I think I'm done now. Okay, good. Who's next? Okay, Nick. Nick, do you want to please walk me through the process under the Ethics in Government Act by which an independent counsel would be appointed?
So after Congress goes to the Attorney General conducts his own investigation, or it takes 90 days, at which point he has to submit a report to a committee of judges.
Good.
Who then decide whether or not to, based on the Attorney General's decision on whether or not further investigation is needed, the judges will appoint an independent counsel.
Okay, good. Thank you. Thanks for that, Nick. So it's a multi-step process, right? So first, the Attorney General is given this report. And then the AG decides, is there sufficient information to investigate further of whether this person, Olson, violated federal law? That's not a very hard standard to meet, right? Generally, the government can investigate anything, right? Anything that moves is violating federal law, right? I don't say that lightly. We're all committing 3 felonies a day. There's so many laws you don't even know about. We're all lawbreakers. After the investigation, or maybe 90 days thereafter, whichever comes first, the AG must make a report to what's called the Special Division, right? What's the Special Division? The Special Division is a grouping of 3 judges in the D.C. Circuit Court of Appeals. And they're actually appointed by the Chief Justice, right? And who was it at the time? This was actually William Rehnquist. And Rehnquist actually worked for Nixon. And Rehnquist had recused in the U.S. versus Nixon. Then he put the stripes on his arms, right? So Nixon, or Rehnquist appoints these 3 judges. At that point, the judges have to decide, you know, is there reasonable ground to proceed? Right? At that point, if there's reasonable grounds to proceed, the 3 judges appoint an independent counsel. And they define that counsel's jurisdiction. So here, the 3-judge panel appointed Alexa Morrison. I don't know if it's Alexa or Alexia. Randy said Alexia in the video. I'm not sure. I'll say Alexia. But Alexa Morrison, she's actually a partner at a firm in D.C. now. She's still around. And she's appointed. Then Morrison, as part of her investigation, issues a subpoena to Ted Olson. And Ted Olson moves a subpoena is a request for documents, right? That's what a subpoena is. At that point, Ted Olson moves to dismiss the indictment. Why? Because Olson says Morrison was improperly appointed. Okay? So the case goes to the Supreme Court. Morrison against Olson. And this case presents a question, was Morrison's appointment valid? All right. I think Sarosh, you're next. Okay. So the first question I want to talk about is, let's go back to the Appointments Clause. And we read earlier that the President has the power to appoint with the advice and consent of the Senate. Who made the appointment here? Was it the President?
No.
Who made the appointment?
The appointment was made by the special counsel, by the special division, which was chosen by Chief Justice.
Yeah. So does the Constitution, Sarosh, allow for the appointment of the independent counsel by judges, by the courts?
According to this, yes, it was.
How do we know that?
Article 3 of the Constitution.
Well, it's not Article 3. What provision of the Constitution gives the President, give courts the power to appoint certain officers? Well, we covered it earlier today.
The appointment.
What does the Appointments Clause say?
The appointment clause says that the president appoints.
It's on the board.
Oh. Right. President shall nominate appointments are here and not here and otherwise provided and shall be established by law. The Congress may by law vest appointment of such inferior officers as they think improper, and the president alone in the courts of because of the courts of law.
Ah. Well, what kind of officers, Sarosh, can the courts of law appoint?
Inferior officers.
Inferior. Okay, so the first question that the courts has to decide, is Morrison a principal officer or an inferior officer? Now, the Constitution uses the word principal. I'm sorry, damn it, I said it wrong. The Constitution uses the word inferior. It does not use the word principal. Right? I just said principal. Where does principal come from? The courts have more or less adopted this term. That is, the opposite of an inferior is principal. Think of a Secretary of State, right, or Secretary of War, or a Supreme Court judge, right? These are principal officers, primary. But below that's inferior. So the court says, if you're inferior, you can be appointed by the courts. Okay? Antoine, is Ms. Morrison a principal or an inferior officer?
According to the majority opinion, they determined that she was an inferior officer.
Tell me why.
Her jurisdiction was limited. She had a limited time in her actual position, so it wasn't like forever. And she was subordinate to the Attorney General.
Okay, very good. Thank you. The majority says she's inferior. And that's not like an insult, like, oh, you're inferior. It just means you're not principal, right? So don't think of it as like an insult. The majority says that she's an inferior officer. This was actually, by the way, a 7-1 case. Justice Kennedy had recused. He had just gotten on the court at that point. And I think he had also maybe decided a similar case involving the Ninth Circuit, but I'm not sure. This is crazy. Justice Kennedy had a case in his final term which he had to recuse on. Why? He had decided a similar case 30 years earlier as a circuit judge, and it was still ongoing. It was some like long Indian water case. I can't remember what it was, but he had to recuse from a case from 30 years earlier, and the court split 4-4. Happens. But Antoine is exactly correct. The majority by Rehnquist hold that Morrison's inferior. Her duration is limited. She's not in office forever. And the court says the president still has control over her. Justice Scalia vigorously disagrees. By the way, Justice Scalia wrote this in his maybe second year on the court. This is, I think, one of my favorite Scalia dissents of all time. It is so well written. It gets better every year I read it. Whether you agree with it or not, that's a different story. But the guy can write. I miss his writing. I do miss it. And this is peak Scalia because it's all by himself, right? He didn't have to make anyone else happy. When you're trying to get other joins, get other people to join, you have to to water stuff down. Now this is Nino all the way down. Oh, Martin's not here. Okay. I'll get back to him. Ruben, yeah, don't go to the bathroom when you're next in line. I know it. I don't mean it's deliberate, but like I'll just come back to you when you're not expecting it, which is why it's bad. Okay, Ruben, what's Scalia's opinion? Does Scalia think that Franco, bless him. Does Scalia think that Morrison was inferior?
He said no because he said that the independent counsel is
Yeah. Well, why is she not subordinate? What about Morrison's office makes her not subordinate, Ruben? What?
Like independent.
Okay, but what does it mean for her to be independent? What exactly does that entail?
I guess she's not under the authority.
What happens if the president is unhappy with Morrison's actions?
Then
What can he do? Or what can't he do? Better
you
quote.
can't fire her
You can't fire her. What's the only way to fire the independent counsel?
with through Congress.
No. What do you need to show to fire the independent counsel? You don't have to go to Congress. What's the key protection? Jessica?
The key protection is, oh, I have it right here. It has to be
How do you fire it?
cause.
For cause. Very good. Martin,
Oh, good call.
what does it mean to fire someone for cause? What does that entail? What does it mean if that's cause to fire someone? What does that mean?
You must have purpose to pursue it, essentially?
Oh,
or-
I think you're right. What do you mean purpose? I think you're right. Just give me a little bit more.
So, I mean,
Can you fire me because I don't like you?
no.
Fire because I just want to go a different direction?
Yeah.
What do you have to actually show?
That there's an actual cause to the,
Yeah, but what would a cause be? You're right.
whether it's something illegal, something.
Yeah. Basically, the person may be breaking the rules, right? They're breaking the law. They committed a crime, right? They commit some act of malfeasance, right? They did something bad, right? For cause means you have to go fire someone for a legitimate cause. You can't just be like Roosevelt, like, you know what? I want to go a different direction. I want a different commissioner. Or Wilson, I want a new mailman in Oregon, right? You can't do that. So Alexa Morrison's key protection is she cannot be fired at will. She can only be fired for cause. And there's one other aspect of her independence which isn't so obvious from the case. The court defines her jurisdiction. Right? Generally, the president can define what his subordinates investigate. But here, the court gets to define it. Let me tell you something. The court will give her whatever she wants. If Morrison says, I want to expand to this and I want to expand to that, they'll keep expanding her jurisdiction. The independent counsel that investigated the Clintons, right? What started it? I don't even know. Whitewater. Yeah. There were land dealings in Arkansas. It was called Whitewater. Hillary was, no. There were all these business transactions that were very profitable for the Clintons in the early 90s. They were magical transactions they only profited from. And they investigated that. And somehow investigating land dealings in Arkansas went into Lewinsky and sex, which went into obstruction of justice and perjury, right? Investigations have a way of expanding. Look at Trump, right? What started off was talking about collusion in Russia expanded into obstruction of justice, right? Prosecutors have this amazing ability to find other stuff to investigate. And when a prosecutor has unlimited jurisdiction, they manage to find whatever they need to find. So another aspect in which Morrison's was not independent was that she could basically investigate whatever she wanted because the courts would give it to her. So in the first question, Scalia says that she's not inferior. So because she's not inferior, Scalia says, she can't be appointed by the courts, therefore her office is unlawful. Okay? The second one I think we discussed a minute ago, is about the good cause standard. The majority says that the good cause standard did not interfere with the president's ability to exercise the law, right? They said, well, it's okay, right? So long as the prosecutor's doing a good job and not breaking the law, she can keep doing it. Scalia disagrees. He would go back to Justice Taft in Myers, right? Chief Justice Taft, saying that limiting the removal power limits the president's power to control, right? Limiting the removal power to for cause restricts the president's ability to faithfully execute the laws. All right. So those are the first two questions, right? Is she inferior? The court says yes. Scalia says no, she's principal. The second question, is the for cause restriction a violation of the take care clause? Majority says no, it's fine. Scalia says yes, it violates the take care clause. The third question, though, involves a separation of powers. Leslie, Why is Scalia so concerned about this third issue, the separation of powers question? This is, I think, what animates him the most. Why is Scalia so concerned about the separation of powers, the third question presented?
He says that it's an overreach into the presidential power, and that in the Constitution it says it doesn't split up the power for somebody else's.
Yeah. Yeah. Why does Scalia seem to think that the executive power must belong only to the president, Leslie? I think you said it, but just give me a little bit more, please. Yeah. Scalia looks at Article 2, Section 1. Article 2, Section 1, which says, the executive power shall be vested in president. Not some of the executive powers, but the entire executive power. Let me just play you a little bit of the audio. This is my favorite Scalia clips of all time. I'm very happy I got this in the video. Scalia would give this speech hundreds of times around the world, so I've heard it so many times I'm tired of it, but you haven't heard it, so I'll play it for a little bit.
The dictatorships of the modern world, bills of rights are a dime a dozen. What makes ours work is a governmental structure, a constitution of government, designed by 55 extraordinarily wise national leaders over the course of a 4-month convention 200 years ago last summer. That structure was designed to prevent an excessive governmental power, which is always the first threat to liberty, from coalescing. To achieve that, two principles were absolutely central. One was the separation of powers among three branches. The second was an equilibration of powers, so that none of the three branches could become too strong.
What is so problematic about restricting the president's power to remove?
Okay, just wanted to play. Scalia would often make this point that what makes our Constitution unique is not the Bill of Rights, which basically every country in the world has, but what makes our country unique is the separation of powers, and the idea that the executive belongs solely to the presidency. And there's this one line which I love. So I know I'm fawning, but this is a good opinion. He often says, frequently an issue of this sort comes to the court clad, so to speak, in sheep's clothing. You know the expression of wolf in sheep's clothing, where you have obviously a wolf dressed up like a sheep. But in this case, this wolf comes as a wolf, right? That the flaws of this law are on its face. So why does the majority and the dissent see the world so differently? I think we can go back to Black and Jackson, right? That the majority is very Jacksonian. It's very functional, saying, well, yeah, this limits the president's power, but it's no big deal. We have this huge crisis with Nixon. We have these corruption scandals. We should go along with it. That if the Congress and the president want to share their powers, we should let them do it. And Scalia goes full on Black, right? He's like, no. The executive power is in one president, not like a little. He called her a junior varsity the junior varsity executive, right? And the JV, right? This all-powerful person who can basically take down an executive. Now again, Morrison was not investigating Reagan. She was investigating Ted Olson, who is an important guy, but he's not the president. Fast forward to Clinton with Ken Starr, and virtually everyone agreed this was a bad idea, right? The Whitewater investigation began with these obscure land transactions and almost took down the presidency. Why? Because once you start investigating someone and they decide not to cooperate fully, aha, you're obstructing the investigation. Sound familiar, right? Once you start investigating Russian collusion, aha, you're not investigating obstruction of justice, right? You're trying to interfere with the investigation. I'm trying to execute my executive powers. No, you're interfering, obstruction of justice. Now, the difference between Ken Starr and Robert Mueller is that Ken Starr was an independent counsel. He was appointed by the 3-judge panel. Robert Mueller was not. Why wasn't he? Because Congress allowed the Ethics in Government Act to expire. The law had what's called a sunset, which means if it's not reenacted every so many years, the law loses effect. What does that mean? Robert Mueller was appointed pursuant to regulations similar to that were for Archibald Cox back in the 70s, right? It was an internal executive branch officer. Could Robert Mueller have indicted the president? I don't think he could have. Could he have issued a subpoena to the president? Of closer call. I don't think he could have. Right? Ken Starr thought he could indict Clinton because he was independent, but the current one was not. I used to teach Morrison v. Olson. Everyone said, "Oh my God, Josh, this was such an awful case. Scalia was right. Right? We don't need, Ken Starr trying to take on the president." And then magically, after 2017, he says, "Yes, we need to bring back the independent counsel statute to take down the president, to keep him in check." So I think that this is an awful idea. I think that you have an election every 4 years. Every 2 years, you have a midterm. If things are really that bad, you can elect a new Congress to take care of things. But it's a bad idea. It never works out well. I don't know. Whatever you think, it doesn't really matter to me. But just it's the experience of the Clinton thing and now the Trump thing was just this long, drawn-out saga that I think did not serve well. Okay. All right. This is one more hard case to teach. It's almost 90 minutes for a single case. There's a lot involved. I could do a semester on this case if I needed to. I really could. Okay. Questions on Morrison? By the way, I think there are 5 votes to rule Morrison. Easy. Had the Trump case gone to Supreme Court, I think they would overrule Morrison. Now we don't have that case because Mueller didn't try to indict the president or didn't try to subpoena him, which I'm grateful for because it kept me really busy. But I think I saw Judge Kavanaugh give a speech a couple years ago. It was like an audition speech, basically, saying, "What are the Scalia dissents that should be majority opinions?" Right? That was his topic, right? Kavanaugh was like, this one he wasn't famous, right? Kavanaugh was like, "What are the Scalia dissents that should be majority opinions?" And Morrison was one of them. So, I mean, he kind of told us what he thinks already. I agree. Yeah, Kavanaugh wrote a dissent maybe about 2 years ago on the Court of Appeals where he basically treated Scalia's opinion as a majority opinion. He just kind of ignored the majority. Anyway. Okay, questions on Morrison? All right, Sergio.
I have a question about, I guess, judicial opinions and how the process of writing them goes. Like, how involved are the clerks? Or is it just simpler, like the justice writes it and they edit it, or vice versa?
It varies based on the justice. Some justices are very hands-on, and other justices are not. You can actually perform. So you know how plagiarism software works, right? You know this from college, right? Where you run your paper through the software, and it says how similar is it to what other people write. Okay, you can do the same thing You can do the same thing for Supreme Court justices, right? In theory, if you have the same justice, their style will be similar year to year, right? They'll be similar year to year. Yet for some justices, there's a lot of fluctuation, right? Their writing style changes in every opinion. That's not because the justice suddenly learns a new way to write. It's because the law clerk is doing a lot of the work. So Justice Stevens, for example, was very adamant he would always write the first draft, which I think is a good practice. Scalia had a very heavy hand. He would do this thing called booking cases, where you would bring the opinion, and then every single source that you cite, you put it on a cart. And you roll that cart to his office, and they check every single citation one at a time to make sure everything's correct. It took forever, booking every footnote, every cite. You check the original source, make sure it's correct. And if that source cites something else, you check the original source. Scalia was very hands-on, which is why he had such a distinct style. Other justices, I think, delegate more. Yeah. On the current court, I think my favorite writers are Roberts and Kagan. It's not even close. Gorsuch may get there. He has his own sort of folksy style. I'm still on the fence about it, but Kagan and Roberts are very good writers. There's some writers who aren't so good, and I have to. Well, let's talk the next case. Justice Breyer's opinion, Noel Canning. That's a good place to start for that one. I don't hate Breyer. Just his writing is just. I feel like I'm being lectured to. It's like I feel like I'm like sitting in a class and getting recite after recite. Kagan, I feel like I'm watching a Woody Allen movie. It's wonderful, and Roberts is just very clean. Okay. All right. It's not what you wanted to hear, but I think I answered some of your questions. Let's talk about Noel Canning, which I have very little time for, but I can make it work. We have this provision in the Constitution, the Recess Appointments Clause. It says the president shall have the power to fill up all vacancies that may happen during the recess of the Senate. This text raises three questions. Right? The first, what is the recess of the Senate? Right? The recess of the Senate. Does that refer to the intersession recess, which is the break between sessions, or the intrasession recesses, which is a break during sessions? Let me explain how this works. All right? Every day this week, actually they're not in session now, but in general, when the Senate is in session, they're not there 24 hours. They'll break for lunch. They'll break for nighttime, right? Maybe they'll go home for, Christmas. Maybe they'll go home for Thanksgiving. They'll break for a couple days, whatever it happens to be, right? There are lots of breaks during the session. These are called intra-session recesses, right? Intra-session recesses, the breaks during the session. There are many intra-session recesses. There are a lot of them. But there's only one intersession recess, right? Each Congress meets for 2 years, right? When you're elected to Congress, meet for 2 years. Between year 1 and year 2, there's a break called the first session of Congress and the second session of Congress. That's the intersession recess. There's only one of those, right? Intersession recesses. Okay? Which recess are they talking about here? Right? Which recess are they talking about here? I think, is that Kobe, you're next? So, Noel Canning considers this question, right? The court's 9-0, right? They all agree that President Obama's appointments were illegal, right? Again, when Ruth Bader Ginsburg says you violated the separation of powers, you really violated the separation of powers. This was I think, in the old days, they would impeach the president over this. Now they just go to court instead. But people are lazy now. They'd rather go to the courts and take the hit. But Kobe, how does the court split on this question of whether the text applies to the single intersession recess or the recesses between, every now and then, right? How's the court split here?
Justice Breyer says that it doesn't matter if it's an intersession or intersession.
Okay.
And Justice Scalia, dissenting, says that it was meant just the intersession since Article 2 says the session.
Bingo. Okay, so here we have Scalia and Breyer disagreeing. And this is no different than Black and Black and Jackson from 50 years earlier, right, in Youngstown. Scalia is a formalist. He says, look, it says the recess of the Senate. How many is the? One, right? The recess. Not the recesses of the Senate, the, uno, one, the recess of the Senate. Formalism, right? And Breyer is like, well, let's be functionalist here. And Jason, what sort of evidence does Breyer look to reject the Scalia argument? That there's only one period we can make these recesses. What does Breyer look to? This is where he goes a little bit Frankfurter. Bingo. What was historical practice about making appointments during the session? Yeah. There is some history. History is disputed, but there's some history of presidents making appointments during the session, right? Where Congress goes home for a month for Christmas, you make an appointment during that time. Scalia responds, no, we can't do it like that, right? This was an issue in which Congress was divided. The president made all these appointments and Congress wasn't happy about it. So Scalia says, let's let the political branches resolve these. Let's not assume the issue for them. But anyway, the first one, Breyer won. That the recess clause applies to both the intersession and the intrasession recesses. As a result, if the Congress goes home for a month for Christmas, the president can make appointments during that time. Okay? The second question I want you to look at is the phrase vacancies that may happen. Katie, let me ask you a question. How does Scalia interpret the phrase vacancies that may happen?
He said he would argue that that only includes vacancies that become vacant during the intersession.
Perfect. Yes, exactly correct. Thank you. Scalia, again, is a formalist. He says, look, vacancies that may happen. That means if a person dies, if the Secretary of State dies while the Senate's in recess, it happened during the recess. And the President can then fill that, right? So Scalia would limit the Recess Appointments Clause to only vacancies that arose during the recess. And again, during the intersession recess, not the intrasession recesses. So there's a very small number of people who this ever would have been applied to. Ben, how does Breyer and the majority read this phrase vacancies that may happen?
Well, they said it was ambiguous at first.
Ambiguous, yeah.
Again, referred to the historical practice.
And did presidents fill vacancies that happened from before the recess?
Yes.
Yeah, so once again, Breyer is Frankfurter, right? Not really even Jackson. I think it's more Frankfurter in this opinion. He says, look, we have history of presidents in the past who filled vacancies that arose before the recess. So again, we have this conflict. Scalia is saying, look at the text. Vacancies that may happen. The text gives us the answer. And then Breyer's like, no. We need to be a little bit more formalistic. I'm sorry, we need to be a little more pragmatic here, a little more flexible. As a result, the court held that it doesn't matter when the vacancy arose. All right. The third one, I think, is the one where Breyer shows his cards the most. The third question is, how long does a recess have to be to trigger the recess appointment power? Recall that President Obama made these appointments during a 72-hour break in the Senate. Now, Obama said, no, this wasn't a 72-hour break. Congress wasn't even in session at all because they did these little silly pro forma sessions that lasted like a minute long. Braden, who gets to decide when the Senate's in recess? The President or the Senate?
The Senate.
Okay. Why?
I think it's part of their powers delegated.
Yeah. Breyer says that the Senate gets to decide when they're in session, not the President. And if the Senate says they're in session and they have the ability to conduct business, they're in session. Now, they may not actually conduct any business, which there wasn't any done this day, right, in January 2014, right? But the fact that they can transact business means that they're in session. But the last question, Kimberly, last question, Kimberly, is a 72-hour recess long enough to trigger the recess appointment power?
Breyer said no, that's too short, but he said 3 days is probably okay.
How many days?
3 days is too short, but he said 10 days.
Yeah, Goldilocks, basically, right? Well, 3 days is too short, but 10 days is just right. Kimberly, where on earth does Breyer get this 3 to 10 day thing from? Oops, crap. Sorry.
Pulls it out of a hat, I guess.
Pulls it out of the hat. Breyer's a huge hat, right? It's an enormous like Lincoln stovepipe hat, right? Where he gets stuff from. Yeah. I think Kimberly's right. The 3-day part you get from other parts of the Constitution, but the 10-day, he kind of makes it up, right? And Breyer's like, well, we think 3 days is too short. 10 days is probably long enough, but there may be circumstances where less than 10 days is okay. Just, we won't tell you. And Scalia's like, what's going on here, right? What is this? 3 or 10? Now, I mentioned this in one of the notes after the case, but this was actually like ConLaw real life. In February of 2016, Justice Scalia died while the Senate was in a 7-day recess. I think I was one of the first people in the world to recognize this fact. Like, I don't think I was the first, but like maybe top 10 people. I was like, oh my God, Scalia's died. Oh crap, the Senate's in recess. And I had this oh shit moment of like, okay, what's Obama going to do? He's going to figure this out soon enough as well, right? Is he going to go put Merrick Garland or someone else in the Supreme Court, a recess appointment? Because that term wasn't over. There were still cases that had to be argued. And big cases, too, which could have flipped the outcome. There was a case about DAPA, a case about the concept of mandate. There were some big cases to be argued. And the other crazy part was the Senate was out. So I actually called a friend in the Senate frantically. I was like, you're in recess. You need to do something about this. And get your asses back in session. And so, I mean, I don't think I was the first, but I was one of the first to recognize this fact. And at that point, the majority leader, who was McConnell, who's still the majority leader, called the White House and basically said, I need you to guarantee that you're not going to make a recess appointment. If you refuse to make that guarantee, we're coming in session tomorrow. And the president said, okay, I'm not going to make a recess appointment. He could have. That would have been a baller move. He could have totally done it, right? But the issue is 7 days long enough? I don't know. It's not 3. It's not 10. Breyer's like, I don't know. Well, we have a Supreme Court justice with the middle of a term. Is that a circumstance that commands it? And could you imagine then, someone then challenges just say Garland. Someone challenges Garland's appointment as a violation of Noel Canning. And then Breyer say, whoa, 7's okay. And they're votes short. Because they're basically voting on their own colleague whether he can be on the court or not. I mean, just imagine the cluster that would have been. It didn't happen, and we all know Obama never got his pick through anyway. But I mean, that could have gone very differently if there was a slightly longer recess, right? Anyway, long story short, when you have these sorts of 3 or 10, stuff happens which requires an answer. And the Supreme Court utterly, completely failed to give that answer. So the Breyer opinion is a sore spot for me. Okay, Matt, you've been patiently waiting.
No, it's okay. I was just going to say that Obama probably should have done it anywhere, or at least cut a deal with McConnell so that if he was not going to make a recess appointment, that this guy would actually get a hearing.
Oh, yeah, right. Yeah, that was going to happen. But I mean, the reason why I'm saying yeah, right, is McConnell had no obligation to do any of that. But it was dicey. I mean, I was for about a couple hours. I was like, oh boy, what's he gonna do? It could have gone. I mean, we've had Earl Warren was a recess appointment. William Brennan was a recess appointment. They were later confirmed to full terms, but presidents have used recess appointments before. That was a very hectic day. I think it was February 13th. It was right around Valentine's Day. Very, very hectic time. Yes, sir, David.
So is it safe to say that you forbidden Obama from?
No, I don't think he would have done it because it was really risky because the entire thing could have been invalidated as not being a long enough of a recess.
He's a constitutional law professor, right? So
Something like that. Yeah. He could have done it, and I don't know what would have happened. It could have changed a lot of things, but that entire episode was very. I wrote about this in my second book, if you want to read it sometime. But it was hectic. Yes, sir.
Do you think that was a character representation, or do you think that he was just biding his time?
Biden his time? No. I think it would have been too risky. Obama was actually fairly cautious. You may think of it. He was fairly cautious. A conservative, not like in the Republicans, but he was fairly conservative how he approached things. I think that would have been a bridge too far. He even tried pointing. Garland, who was quite moderate. I don't think he was moderate, but he was more moderate than someone else he may have picked otherwise. He wanted to try and get someone through for the long haul. Had Obama done a recess appointment, that would have, I think, killed any sort of vote on his nominee, which happened anyway. So 2020 is hindsight. You can never know what's going to happen at the time. Yeah, Richie.
I was just going to say, if Obama would have done that, then we would have had an answer from the Supreme Court.
We've had who?
We would have had an answer about what was too long or too short, and more than likely.
Oh boy, yeah. I mean, but at that time, the justices would have to decide: is your colleague legal or not? And the five votes in Noel Canning were still there, but you're down to 8 justices. The court got split 4-4. In which case, you affirm the lower court. And to be frank, the only way to challenge, let's say, it was Garland's recess appointment was if Garland decided a case and the person affected by that judgment would sue to argue that that judgment was not valid. In other words, you can't just go to the Supreme Court and say, hey, is Garland valid, right? You'd have to basically wait till Garland renders a decision and say that decision can't affect me. And that could, I mean, you now have an entire Supreme Court term where the opinions are in jeopardy, which is why I think Obama would not have done it. It was really risky. Could have done it, but risky. Yeah, Serge.
So what if it had gone through and there was no challenge till, and now we're in 2019 and then there was a challenge?
It would have probably taken about a year or two to actually get a challenge through. Yeah, at which point, well, I mean, at that point, Garland's nomination would have expired, right? So the court could have just said, well, even though Garland wasn't appointed properly, we'll just treat his decisions as if they're okay. But complicated, messy. All right. Let me sum up because I'm running a little bit short on time. The opinion in Noel Canning, which I went through way too quickly, but the opinion in Noel Canning is significant because it articulates very different views in the world of how to approach separation of powers. Breyer was saying, let's let Congress set their boundaries, right? If Congress wants to share this power, they can do it, right? If Congress wants to allow the president to make these recent appointment powers, we should let it. Well, Scalia is like, no. The executive power is in one president. In Morrison, he was very pro-president. Here, he was very pro-Congress. Scalia is like, we need to guard Congress's powers. We can't let these overbearing executives intrude upon them, right? So in one case, Scalia is very much pro-executive. In the other case, he's very pro-congressional standards. And all things considered, Breyer and Scalia are very good friends. They actually went to testify in front of Congress, either before or after the case, I can't recall, but around the same time. And they articulate their different visions of the separation of powers. Scalia's like, we gotta keep them separate. Breyer's like, oh, we can let them merge. Not that big of a deal. Okay. Questions on Morrison or Noel Canning? All right. I think, is your Langdell this weekend? Or is it next week? Okay. I talked to Tim. He's going to be giving one of my old midterms at that Langdell, so you should consider going to it. Today we have, for class, I'll pack up in a second, I'm not done yet. For class on Tuesday, the 8th, we are moving to a new topic. We're moving on to the Reconstruction Amendments, and we'll start with a case that needs no introduction, which is Dred Scott. The reading is not too long, but make sure you read it carefully. Okay? All right, I'll see you all on Tuesday. Thank you very much. Yeah.
Was there?
Oh, okay, just 1 second. Let me ask this question. Yeah, go ahead. Sorry.
In Morrison, when they talk about that second issue in the removal power, was there a new test that comes out of that that's still relevant? Or?
Yes, of whether. Okay, so let me just make sure I read to you correctly. Just give me 2 minutes, and I'll get you out of here in time. In Morrison, there was a second question, right, of whether the good cause standard limits the president's power permissibly. And Rehnquist says, I'll give you the quote, "We do not think that in this case the good cause removal restriction unduly interferes with the president's exercise of executive power and its constitutional duty to ensure that the laws are faithfully executed." So the standard is, does this restriction unduly interfere with the president's powers? That is utterly useless as a standard. What the hell does that mean? Does it unduly interferes? I don't know what that means. I've had to consider that question with Mueller, but that's the standard. That's the test.
Thank you.
I'll see you all on Tuesday. Thank you much.